Madan Mohan Rao garu. Now I request to present A. Jagan garu, Telangana High Court Advocate Assistant to kindly around the chair and the dais. Now I request E. Madan Mohan Rao, visited Senior Councillor to kindly around the chair and the dais. And I request our Vice President Rajesh Reddy garu and Investor Reddy garu around the chair and the dais. Today we are going to conduct the lecture of our senior designated counsel Madan Mohan Rao garu, who born in the year of 1980. He was designated senior counsel in 2021 and he is a revenue GP for 11 years in combined state. Now I request to our senior designated Madan Mohan garu to give the valuable lecture on the revenue laws.
Revenue laws is a very vast subject. In fact, enactments are concerned. There are more than 56 enactments applicable only in Telangana. So what are the actual parameters on which enactments so that tell or whatever it is assist in sense, tell about the problems anything faced by you in the day-to-day or legal profession aspects or general revenue laws shall I address? Please suggest me on the basis I can proceed with that.
Daily subject is Telangana Rights and Landlord-tenant Act, Inam Abolition Act, and Buff Act.
Basically, as far as our legal profession is concerned, as Jagan said, we will be generally dealing with first Tenancy Act, 1950 Tenancy Act. One, then 1955 is concerned in Abolition Act. Then other subject is concerned 1977 ASSN Act. And thereafter we concerned to the 1971 RO Act. These are in fact the principal acts which in fact we deal in everyday court cases, regular cases. The revenue laws and administration is concerned, as far as Telangana is concerned, from the Nizam onwards, revenue administration is to be done by the farmers and the regulations issued by the Nizam government. Actual regulations have started somewhere in 1940s and 30s itself. 1938 regulations, records of rights regulations, the Jagir abolition regulations, all these regulations are there. Coming to each one subject wise, first subject is concerned, the general law with regard to the Telangana is concerned. Telangana Land Revenue Act deals with all these subjects. There is almost like our civil procedure code which we do civil cases, that in fact covers first legislation 1370 first legislation, which covers in fact all the aspects of survey, what is the nature of the lands, etc. All these provisions are incorporated, consisting of various during the 1317 first itself. In 1317 firstly, there are 3-4 provisions which incorporated by the state at the time. At the time is concerned section 24, stating that all the roads and etc. properties and whatever it is are vested with the state. And other provision is concerned section 58, because those days you know that most of the land is held by the state, not by the individuals. Very few individuals were having the owning and we were not having a particular titles, and the registration act also very less implementation was there during the Nizam years. The occupation of land, because they used to occupy a government land because of the most of them poor. Therefore, section 57, 58, etc. provided saying that occupants can have the rights, occupancy rights, that is to be granted to them. And those rights have been recognized under section 58 of the Telangana Land Revenue Act. And the act says that whatever the occupancy rights in the nature granted by the state, that those occupancy rights are transferable and heritable. That's how this the transfer, heritable, all these things are started, emanated from that legislation onwards. How the transfer will be effective. Thereafter, when we come to the 1948-30 police action period, the Nizam used to run the administration, revenue administration, by way of farmans, as I said, by way of regulations, Nagi regulations, etc. Those started abolition of those regulations. Because you know that earlier, the state, in the sense of the Nizam, used to hold the land. By farmans, he used to grant, or by Mutakabs, he used to grant some grants, and Mutakab is also grant as well as succession. He used to give to nobles like Paigas, who were working in his army, and the poor some pattas. And he also, 1950, prior to the dawn of the 1950 law, like the state used to distribute those lands to the persons who are in possession. Then after this, he used to also give jagis to various people. He has given jagis, Kandike, Farmans, various Mutakabs. Number of jagis have been created. He has given Inam villages. Watandari system was also there. Certain Watans have been given. This was held by some of the Watandars, some of the Jagirdars holding number of villages in their control. They used to control, Jagir administration used to be there, state used to collect some revenue, and the Jagir regulations they used to cover. By the time of the 1948, police action and also the country's situation of independence, the legislations and revenue legislation started. The first legislation, I said, was the Tenancy legislation, that is 1950. Prior to that was the Jagir abolition. 1949, Regulation 15, which abolishes Jagirs. That's the first legislation. All the Jagirs which were held by the so-called grantees from the Nizam, their Jagirs have been abolished under the circular, and the persons who are the cultivator, who were in possession in the 1954, etc., after circular 2, they were all granted Patadari rights. That's the first legislation, they granted occupancy rights. And those rights, as I said, under 58, is a protection is possible for transfer and also etc. that was there. Then the tenancy legislation was introduced in 1950, whereby tenants, protected tenants have been created and tenancy have been given a statutory status, giving him rights, not only tenancy rights, cultivation, period of tenancies, etc. Suppose they are reached, the procedure for their restoration, etc. have been provided under the Tenancy Act. And thereafter came the legislation is another important legislation where this Inam has been abolished. That is 1955 Inam abolition. By which Inams have been abolished. Inams also definition includes Paigas and other grants, Fasikas, whatever it is, Baktas, everything. Whatever the Islam used to give, Jagirs, Baktas, all these things under Jagir abolition regulations and also under the Inam abolition have been abolished. But the grant of the pattas only as far as Jagir is concerned was provided at a circular to the persons who are not provided. But Inams are concerned the occupancy rights were number of sections were there under section 4 to 10. But those sections were not implemented. That's how these legislations as far as the revenue legislation which is controlled the patadari rights, occupancy rights, which are transferable heritable started. There is another legislation which is represented government land giving an occupation is concerned. Lavali Rules 1950 was introduced to give some statutory color. Those rules, all these regulations in 1959 regulations, 49 regulations, this Lavali Rules under 1950, and also even record of rights preparation. All these rules have been made under section 172 of the Telangana Land Revenue Act. By rule making power, these regulations have been made. In that, one of the important regulations is that land transfer regulations, the 1358 firstly, that's the records of rights, regulations were there. And those regulations subsequently 1971, those regulations have been repeated and ROR Act has been given 1971 Act. All these occupants' rights or an acquisition of rights, wherever title, those can be incorporated in the records maintained under the ROR Act as per section 4, section 3 of the Act. That's the basic structure of the revenue law, basic structure of the provisions, how the occupants, Jagirdars, Inam abolished and they are being granted the pattas, and then respectively they were given conformative, etc. And their incorporation under section 4 of the RO Act. That is how legislation up to 1971 went. And the Assigned Land Act 1977, that is also, you know, that 1406 assignment, this Lavani assignment in 1950, and other assignments, and general government also issued the farmers, even after 1956 also, government given certain concessions to schools, schools. All these things to be regulated. As for the assigned lands are concerned, the landless pool is concerned, Act 9 of 77 is brought. The assignment is given to landless pool, who is defined under section 2 of the Act. They cannot sell the lands. If they sell the lands, that is, the prohibition is contemplated under section 3 of the Act, and the machinery is provided in section 4 for violation of initial action, and section 4A, 4B provides for the appeal, etc. That's how these regulations. The rest of other regulations are concerned. Agency area regulations 1959. There's the agency regulations covering Nagaravan, Hamnovis is also there. There's also vast areas of data revenue laws. And the revenue administration not only consists of general administration, land administration. The land administration pertaining to that, since we are the lawyers, we are concerned with the overview of how the land is in Telangana is transferred, what was the capacity, as I said, Jagiri and Inam capacity, how it is turned into occupancy rights and titles. As for the first legislation which has stated one about the Jagiri abolition, that is circular 2 provides for it. The persons in the question 1954 will be entitled. Automatic, they are getting the ownership and paternal rights. The state has to incorporate those in 1954, and thereafter they have the absolute rights by virtue of section 58 of the Telangana Land Revenue Act. They can exercise paternal rights. Paternal rights is nothing but a general speaking of right is a ownership or a title or a control, including the transfer. As for the Inam Abolition Act is concerned, one of the friend asked me about Inam Abolition Act. Inam Abolition Act in 1955, it has been Inams have been abolished. All Inams have been abolished. Whatever the grant in place, the Mother March, or Inams consisting of various Inams, service Inams, charitable Inams, endowment Inams, and other as a gift Inams. Those are a number of nature of Inams. All these kinds of Inams have been abolished. And this main important section is section 3. Section 3A of the Act abolishes. Section 3A of the Act abolishes all Inams and vests in the state. All Inams. Section 3 2B it says that all Inams are abolished, but the rights who are in possession, persons who are in possession, they are entitled to get occupancy rights. The section 4 of the Act, section 5 and 6 up to 8 of the Act provides the persons who are entitled for the occupancy rights. Section 4 provides occupancy rights to the Inamina. In respect of Inamina, who was granted Inam, his stand is abolished. Suppose he is in possession, this abolition was 1955, but the rules had been framed in year 1975 in our abolition rules. And the rule 5 has been incorporated. By virtue of that, the grant of Inams from the rules have been provided from date of making application. That date has been taken as a 11173 for grant of Inam occupancy rights. The section 4 is in respect of Inamina. Section 5, 6, 7 is in respect of the protected terrain and also Kabisa and also non-protected tenants. These people are entitled subject to satisfaction of their respective section 4, 5, 6, 7, 8 of the Act. Section 4 is concerned who is an actual cultivation in possession as per the rules what I said, rule 5. 11173 is possession, he is entitled to the 2 standard holding subject to calculation, etc. In respect of the agricultural land holding. The rest of the non-agricultural lands, etc. is covered by section 19. With the tanks, etc., all these things, lands will be vested with the state. As far as the protected tenant is concerned, also, suppose he is in possession about it, on 11173 is subject to 4-1 landlord holdings. After giving the landlord holdings, whatever the remaining area is concerned, he will be entitled also occupancy rights at the beginning. Like Kavita Khalil also has been defined in the Act under Section 2, the person preceding and 173, Section 2. Suppose he is also in personal cultivation and also occupation, he is also entitled. Like that person, suppose he is not a protected tenant within the meaning of the Tenancy Act. He is a not protected tenant. Suppose he is in long possession, after 1957, there can't be a protected tenant, but he is in possession of it. Suppose he is in possession after 173, preceding 12 years, an actual cultivation. He is also entitled for occupancy rights. Those rights will be determined under Section 9. Section 9 is concerned if a non-residential land structures and buildings are there, for example, something outhouses, etc., whatever it is, those buildings will be excluded of an inquiry related to that. That is concerned. Section 23, 24 provides for the Constitution whether who is entitled for the buildings, etc. As for the land, agricultural land, which is under cultivation of the respective categories. Inam, the Kavita Khalil protected tenant. Under Section 10 of the Act, the collector also defined including the RDO, subdivision officer, whatever in capacity. He has to inquire into the nature of the Inam land, whether it is service Inam, endowment Inam, or Inam given for the grant for the purpose of doing the state duties like that. For example, bypass, etc. They were given because they were doing military services, etc. Those people will be entitled for the section competent authorities, RDO. RDO will grant under Section 10 of the Act to the extent of his holding, subject to the holding, and subject to the satisfaction of the two conditions stipulated in respect to going under Section 4, cultivation and possession on 172. And appeal is also provided under Section 24 of the Act. And the revision is also provided under Section 29 of the Act, the High Court. The people are filing we file ourselves number of cases, all of us file petitions, sometimes solutions, and this is all. In that little issues with number of times, who is entitled for it? Whether person PT is there, landlord is there, who will be granted? Actual possession on one level 17 is the criteria, subject to standard. Those are all the issues which will come. We have to go into the section and see the sections who satisfy those requirements will be entitled. Another important issue which recently has come is concerned whether the Inam, this included was abolished. 1955 abolished. Occupancy rights are not given immediately, which are to be computed after 11173 to be given. In the meanwhile, what happened? Because of the long period, all these persons have entered into a number of agreements, sales. Some of the people have also executed sale deeds without having occupancy rights. There's a lot of debate, a number of judgments on that aspect. Whether the Inamidar can sell it, whether Inamidar, suppose Inamidar was an old grantee holder, whether the brothers are in legal heirs, whether entitled for the partition. All these number of judgments, number of issues went up to the Supreme Court, and the Supreme Court, through the late cases, Bandhavati case, etc., said even during the tenure of the Inam also the partition should be maintainable. Earlier views have been set aside. The holders also they can have an arrangement, can go for the partition. And also the law was Kodara Kesoru's case was 1978. Journals reported, Justice Jeevan Reddy and others said that Inamidars can also sell because his right under Section 3(2) he is saved. Therefore, he can sell the property. That's the purchaser also gets rights into that. Subsequently, 2-3 division bench judgments, Ramadhan and Ramadhan, consisting of Justice Buyar and other 2 other judges. They have said that earlier law with regard to the Section 2 Inamidar selling, the properties are concerned. What they said is that without obtaining your occupancy rights, the rights deemed to be nebulous and it is vested in the state only. Until that occupancy rights are granted, the question of selling does not arise. Not only the Inamida, they have also said in the para 68 of the judgment, which is 2023, page 1 of ALT, page 83, it has been reported. 2023, 1 ALT, page 83, para 68, they have said it also applies to even the protected tenant orders. Unless you obtain occupancy rights, you cannot sell it. You cannot sell it, and successor interest will not have the right to claim. That means, suppose any transaction took place or any document of transfer took place, an instrument of transfer took place, those people are not entitled for seeking an occupancy rights from the under section 4, 5, 6, 7 to the Act. The persons can only obtain after 170. That matter is pending. There is a debatable issue is concerned. The one issue is with regard to that is a prospective or retrospective. The bench has not clarified it. As on today, since clarified, no prospective overruling has been held by the bench. It is to be taken that, and the Portal case has been specifically overruled by the full bench. It is to be taken that it applies to all, it affects all transactions held previously. There is a dispute, certainly they can always raise saying that the transaction is hit by full bench, because the legislation or any interpretation of judgment giving full bench will relate back to the provisions of the Commencement of the Act. That's a law, that's a general law interpretation. Then coming to the second legislation, if any doubts are there, you can ask me subsequently I can clarify. Then let us examine the next legislation if we come across in regard to the ASSN lands are already told. Section 3 is a contravention and action under section 4A, B, etc. appeal to the collector, a revision to the this thing about it. If any assignee transfers, transfer is prohibited under section 3 of the Act. Then coming to the Tenancy Act. 1950 Tenancy Act is one of the, I think, first legislation in the country whereby the landlords, even the pattadars, all lands, the persons who are in possession in the capacity of the tenancy have been recognized. In fact, the first legislation, I think, in the country. This is one of the agrarian reforms, thereby the object of the constitutional goals to remove the intermediaries, and the cultivator, tiller should get the rights, because actually he is tilling and the inamidar intermediary gets the money and he gives to the ruler. That system has been abolished, and the tenant has been given tenant recognition, statutory recognition of his rights, and his rights cannot be taken away by virtue except whatever they provide under the Act. And the statute regulates the entire relation between tenants and landlord, irrespective of their whatever the arrangement, irrespective of the degree or anything about it. And that provides who is a tenant. The principally that's under Tenancy Act we come across with the litigations with reference to tenancy, who is a tenant. Section 34 of the Act, Tenancy Act, deals with who is the protected tenant. It says that whoever is a tenant, oral or whatever it is, written or any capacity is a tenant during the period 1958 to 1956. And I don't want to read the provision, it will take longer period. The section 34 A, B, C gives who is a protected tenant. Basically, to understand it, 1948 to 1956, who is a tenant in whatever the capacity, that person is recognized as a protected tenant. If there is a dispute with regard to landlord, third party has no right. If a dispute between the landlord and tenant, or if a tenant rights have been disputed, that whether he is a tenant or not, under section 35 of the Act provides for a determination by the Tehsil, an inquiry and claim, etc. And another provision is that with regard to section 32, which is, suppose you know the plight of the occupants, those days, the farmers, the landlords used to, Nawabs used to exercise all physical and powers. They used to be dispossessed and all, etc. And we were having very few lands of agricultural lands. Agricultural lands, vast expansion took place after 1969, agricultural revolution, etc. But prior to that, with very few pasture land, with very few agricultural lands. So they used to be evicted, they used to transfer it, they used to gift it, split, and what kind of things, landlords, vested interest used to do. To protect that, section 32 is the provision is provided. Any disposition by the landlord or any person under section 32, Tehsildar can restore the possession. That is specific remedy, special remedy has been provided, so moto or an application. This is a vast, really drastic provision contemplating in 1950s when we have no regular procedures in laws. Now by framing a law is easy. We know the laws, how to be framed and all that. We have learned in the last 75 years of our existence. So 32, 34, 35, these are all the measures for the purpose of the tenancy protection and the statutory interest and regulation of it and the fixation of rent, etc. All this has been provided. Apart from that, the original act itself concedes in the event of selling or consent, the prohibition has been put up. Section 38D of the Act, Tenancy Act. The landlord has been prohibited from selling the land. The one of the best legislation whereby 38D mandates that landlord who wants to sell it first inform to the notice, give notice to the protected tenant whether he is willing to purchase. If he is not willing to purchase, then only he will have a right to sell it. Because that is limited reservation provided because landlords also have some personal necessities to sell the properties for various reasons, maybe health reasons or he's running his family, etc. Therefore, to protect the tenant who is a tiller, this provision of 38D has been provided total prohibition of the agricultural land by the landlord except following the procedure under 38D. And also 38 also provides for it, 38A, B, C, etc. Purchased by the tenant also. Tenant if purchases, it also provides for the mechanism of arriving at the price also. 15 times the land revenue, etc. Rules are also there. Section 38A also provides 38A, 38, 5, 6, etc. 7, 8 provisions are there. How to 38A, 38B, when the consent is given landlord for the transfer, all these provisions are there. Apart from this, another important provision under the Tenancy Act is 38E. 38E is one of the important provisions. It is also one of the, I think, one of the best legislations. It is in 1979, brought in Act 2 of 1979. That legislation provides, till this, up to 1973, the statute was protecting only the tenants as a statutory tenants, but no conferment of ownership. The first time in 1973, from 1/1/73, whatever the notification date is 1/1/73, 38E contemplates, E1 contemplates that whoever is a protected tenant on the set date, on notification date, will be entitled to ownership on the grant of 38E ownership certificate, that is 38E2, 38(2), he will get absolute right of the ownership. The title of the property transfers axiomatically, free from all encumbrances, from the landlord to the tenant to the extent of his possession, excluding the standard holding of the landlord. Thereby, number of people have got 38E certificate, they have become the owners. That is the part of the aggregation, the aggregated reforms in Article 31 of the Constitution of India to make the tillers or the persons cultivating to get the ownership certificate. There is concern, a number of cases will be there with regard to very less cases now, but there earlier used to be some cases, still some cases are there. How to grant it? Mere possession on 1/11/73. Whether possession, suppose he is dispossessed, what is the position about it? Whether dispossessed, any limitation of general law, limitation of 12 years. Let's take the 12 years general law limitation applies. That number of decisions are there. And one of the celebrated judgment is Sada versus State of Tesla Ruplu, 1988 AP page 77. The parents from 64 onwards, the discussion. And earlier, Chennai's case, all these cases, a lot of cases have been considered. Those cases have said he should be in possession, actual possession on 1/11/73. But those that all have been overruled. And it has been held that the possession, even if he is not in possession, he is entitled for ownership certificate, provided he satisfies the statutory requirement of the protected tenancy. And 38E2, a proviso has been added. And the proviso, the Tahsildar can restore the possession, even if he is not possession. By restoring the possession, ownership rights can be granted. By granting the rights, ownership rights, the possession can also be restored subsequently. Not only under the 38(2) and other supplementary provisions under of the Act, also it can be, possession can be restored. Thereby, that legislation completely protects the tenants for the statutory tenants, and also not only protection of tenants' rights, it covers with regard to granting of ownership. We will have some number of cases where who is entitled to 38 certificate, that we will contest on the ground of date of possession, legal heirship, etc. Those disputes will face regularly in the courts. And that legislation also contains with regard to applicability, one or two, another section important will have it, whether it applies to agriculture, non-agriculture, whether urban lands, etc. There are a number of cases on that. Whether unless notification under section 1 or 2 of the Act, otherwise all lands to be treated as agriculture lands and the provisions of Tenancy Acts. But one of the judgments also taken into saying that even the local legislation like HMD Act or a Municipalities Act or a GST Act also gives the notifications. Those notifications also can be, but there is no notification specifically not contemplated under 1 or 2 also judgments are there. As per tenancy concern, and section 98 and other provisions of that gives an exclusive jurisdiction to the revenue tribunals to decide with regard to the rights of the tenants under 35, their recovery portion of 32, and also grant of 38 provisions. And appeals are provided in section 91, section 90, and section 91 provides for the revisions. This is basically Tenancy Act. Section 40 is succession. Tenant succession is concerned because 1946 I said, or 1946 is in position. Because he's not in a tenant must have died. Always tenant legal heirs can apply for succession. Under section 40 succession will be granted. Succession can be granted to all the legal heirs.
As per my knowledge, there is no specific authority to Tehsildar to grant succession under section 40. Whether he is empowered to or not.
Then according to me, that this is a special legislation. Section 40 empowers the Tehsildar to decide who is a tenant and to grant the certificate. Suppose any dispute is there, among the heirs saying that you have got a second wife, you are a third wife, or a suppose adopted son. In that criteria, that issue Tehsildar cannot decide. That is based on the civil right or an inheritance right. That right has to go to civil court. But the Tehsildar is a special legislation. Tehsildar in the section 40 is a duty bound to go into the nature of the land, duty bound to go into the nature of who is the tenant, who are the legal successors. The dispute with reference to civil right of claim of inheritance or a succession, that may go. But Tehsildar is 90% empowered, 90%. Very few cases you will have a saying that unless there is an arrangement on them, or a different wives, or a different persons, different identity, different situations will arise. Those situations, for example, who is the correct tenant? Suppose Ramulu is there. I am Ramulu, he is Ramulu. Ramulu claims are different, this Ramulu claims are different. Tehsildar may not adjudicate saying that who is the correct Ramulu. Unless prior facie satisfies, still he can grant it. If he feels dispute, that's a complicated question is there, then question of civil court. That is one case is Mia's case, I forgot his name, 2007, previous court judgment is there. He also said disputed. Thereafter, Justice Nasim Reddy also deviated that and said it can be granted. Tehsildar is exclusive jurisdiction. The revenue authority is exclusive. A serious dispute is there, certainly this dispute with reference to inheritance, succession, or a civil right. Then go to the civil court. But the summary inquiry, this part of it is concerned, Tehsildar has exclusive jurisdiction. Then coming to the most, I think, live topic for our case and number of cases under the RO Act. RO Act will have a number of cases regularly. I think in the regular courts we will see number of 3-4 petitions, there are 5-10 petitions for RO Act. RO Act, I said as far as it is concerned, first legislation codifying the RO is concerned, RO regulations like 1358 first. Those regulations also contain with regard to the authorities who and records of rights maintained under the regulations. The same parameter regulations have been provided under the RO Act also. Regulations also. That regulations were not statutory, Those regulations in the form of a statutory framework framed under 172 of the Telangana Land Revenue Act. It was also comprehensive, not comprehensive, because the appellate mechanism is provided to PA, collector, DRO, all these things. There was a lot of dispute with regard to the inquiry mechanism was not proper in the regulations. Therefore, the Act was passed in 1971, Act 26 of 1971, regulating the records of rights. Records of rights is nothing but defined under Section 2 of the Act, Section 2A, 2B of the Act, is the records maintained. Actually, this revenue records concept, were the main basis for his gas concern. Telangana, as for Telangana is concerned, the Nizam used to, for the purpose of revenue, because at that time these taxes, excise duty, central excise, customs, sales tax, these are all not the duties. Revenue administration, they used to get the jagis and all this revenue taxes was one of the main sources of income for the state, that state to run. For the taxation purpose, this used to record maintain who was the actual cultivating, who is getting entitled that. This initial system was to getting some produce, thereafter revenue collection. Like that, under various circulars, thereafter 1358 regulation, I will not go into that very vast circulars, no many farmers, etc. is there. Ultimately, a small truncated regulations 1358 is framed. The object is that to made for the collection of the land revenue. And object is to have the person in possession for the purpose of collection. It also provides with the owner patadar, whatever it is, limited extent to be recorded. But the recording purpose is object is for the state purpose, not for the purpose of the ownership conferment purpose, not for the purposes of recognizing the ownership or a patadar, etc. That concept was not at all there up to this thing. The 1971 first legislature thought, no, this is to provide some statutory records. By the time we expanded a lot, number of transactions, agricultural transactions are taking place. In fact, you see the 1950 Act, the sale of agricultural land was also prohibited under Section 47, 48 of the Act. And the validation mechanism under another provision is Section 50B. Because at that time, because family, you know that Bengal farming and other farming, the food prices used to be there. Therefore, the agricultural lands were not permitted. And after these abolition regulations, etc., the economic empowerment made the people to purchase it. Purchase power was very less. So the number of transactions in our area is concerned. Unregistered sales and go to the number of this thing, Patel Patwari system, Police Patel, Mali Patel system was created by the Nizam. And those people, Police Patel used to report to as I said, revenue consisting of not only general administration of law, of the properties about the land administration, of the general administration of the state affairs. The Police Patel used to report to the concerned Nayabdar, Nazim, whatever the names, so-called the powers and etc. That system was there. Under regulations 58, there is some system of incorporation. But 1971 regulations have given some definitions, patadar, owner, and other definitions, occupant, etc. And the first time the statutory legislation providing incorporation of the names of the revenue records, mandating initially by issuing a notification by the Commissioner of the Chemistry. First is taking out the entire lands under Section 3, Preparation of the Land Records Act. The statutory status given to the preparation of the land and the land incorporation started. Initial three preparation for the state, and the rules provides 15, 16, etc. Whatever the state was provided the whatever the basis under 1358 regulation, whatever the inquiries done by them, those were Section 3 contains. Section 3 also contemplates claims, etc. to be completed. And the major provision which we come across regularly, three inquiries we will not generally come across. We come across with the Section 4. That is Section 4 contemplates whoever acquires the land by way of transfer, acquisition, or a succession or occupancy rights or a batta, whatever the nature of batta. Maybe by the time ASSN batta 1406 is there. Even those battas, occupancy rights, even the mortgage rights, under Section 4 incorporated. Section 4 is a very elaborate provision about it. Provided that Section 4, the persons who acquires the rights in whatever the capacities which I narrated, those capacity persons can get incorporated their names in the revenue records maintained by the state under Section 3 of the Act. It's already a primary basic. Records have been village, have been maintained, other very rules and procedure are there. That is the administrative procedure. This is the procedure recording by the person who is in the capacity want to get it registered as a mortgage or whatever it is about the capacity. And the section 5 provides for an inquiry. Section 3 provides for an inquiry and passing an order by the Tehsildar. And the section 5.5 provides for appeal by the appeal to the RDO. Section 9 provides for the revision of the collector. That was the ROR mechanism of incorporation. The two other provisions are important. Giving in section 6 is concerned giving the Patadar passport. Whoever name is incorporated, whoever order has become final under 5.3 with reference to section 9 of the Act is entitled for the Patadar passports under section 6 of the Act. For section 6 of the Act, Patadar passport is a ministerial act. There will not be inquiry. The inquiry has to be done primary adjudication under 5.3, 5.5 and 9 of the Act. The order under 9 shall be the final, subject to judicial review by the High Court under Article 226. That is the mechanism. And in the meanwhile, one of the legislation was section 5A. 5A is concerned with regard to number of, in fact, Telangana, most of the transactions were because the registration office also used to be located in the district headquarters. People district headquarters coming itself was with no transport, nothing, no facility, just going to the Mali Hotel and getting recorded in the revenue records or having some Sada Bainama which is called. That is the provision as far as this thing. The first time legislature has provided 5A regularizing, giving under Rule 26. So what are the modalities for regulation? Rule 26 contemplates that we should have a Sada Bainama transferring, that is called an unregistered sale. Sale parameters should be there and we should be the actual person. And it is actual position. With the unregistered sale conveying document, the document should convey rights. In the event of it, Tehsildar can regulate it. It also provided any dispute among them, section, appeals, etc. I think that was extended. Actually, initial period thought of for 2 years or 3 years, it has been extended. I think something 2019 or 2017, I think it has been extended. Those inquiries are conducted. Then come to the, as far the ROR is concerned, the major is concerned inquiry, incorporation, and number of people filing petitions, etc. When there are fraudulent inquiries concerned, there is various case laws. The person without having a document get it registered, that's it. Our legal subject, it may not come into the as such revenue laws. As far the illegal entries are concerned, the section 6 of Arms Act also says presumption. That presumption is concerned whether the record may change because statutory basis that presumption means that until contrary is proved, the presumption to be taken, that presumption will have a prima facie value in the civil court or wherever any rights of properties being adjudicated. This primary record will have a basis and this primary Patadar passport will have a basis for the getting loans from the cooperative societies and banks, etc. This is the basically ROR Act. And coming to the controversial issue which we face is concerned, the 9 of 2020 introduced by the previous government. The previous government thought that, as I said, the fraud took place, number of people, some capacity coming and getting incorporated, whatever the means of agreement and sale, some succession, etc. There is a one act used to be called with regard to Atyati Inquiry Act 1952. Because the persons who were granted jagis, who were granted inams by the then state, they were granted in the Vasikas and Mutakhabs, they used to call. Mutakhab is a grant and also succession. So, under Atyati Act, we used to get a grant and succession. That is, the grant is actually speaking in the Supreme Court judgment 67 Supreme Court is concerned. It's a lifetime. The succession is provided in the Atyati grant. The Atyati grant section provides 15, etc. That provides for the procedure. Atyati courts are also there for determination of it. And Atyati court, like our civil court, has the power to take the lands and as a custodian can act as an owner itself. So some of the people, huge extents of knobs, having 300 acres, 500 acres, 1,000 acres, just getting legalization, getting it, number of petitions filed, getting incorporated, all these things. And Tehsildars were conducting inquiries. The person who now posed the question to Suresh was a revenue official of his hand collector. So all these frauds took place. To avoid all these things, what did then the government authorities that no, these revenue officers have become lot of corruption, and without proper adjudication mechanism they are doing it. They want this adjudication mechanism under the revenue administration is becoming problem to the people. They thought this is to be removed. Essentially, this system of adjudication to be removed. Therefore, village administrative offices system has been abolished. Prior to that, village administrative office, police officers, village officers, that was removed by the Indian government. Like that, this Act 9 of 2020 brought. The issue since 1920 Act was they wanted to have this manual record maintaining this lot of interpolations. And the pahanis are not being maintained. Pahanis, some of the officers in fact deliberately destroyed the pahanis. One of the pahani, in fact, Telangana area is concerned, Kasra Pahani. This you may come across in the various cases. But the Kasra Pahani is prepared under the rules frames under 1946 census rules. It's a little statutory flavor. There is a first inquiry undertaken by the magistrate and a proper inquiry following the Jamabandi system. That has some credence, more credence. That 54-55 Kasra Pahani, the courts have also recognized the importance of it. That is being done a lot of credence of it. So these all the illegalities took place. The object of 9 of 20 was to abolish it and to make instead of this record maintenance etc. concerned to digitalize, which in fact they execute the instructions, they came with a digitalization by 2017, 18, 19 onwards. But they gave a statutory status under Act 9 of 77 called as Dharani and said everything will transfer to Dharani portal and every correction has to be done. They issued some circular 1 of 2021. The collector and in consultation with the commissioner, Dharani portal can be corrected, etc. So that legislation covered till now. Latest Act of 2025 is passed. Latest Act of 1 of 2025 is passed. English, 1 of 2025 is passed. So that is the Dharani portal concept came. The problem is that Dharani portal is that I said one circular 2021 was there, the circular collector, but the online procedure was there. Online procedure was not providing for making proper applications and the capacities of what we are unable to feed, which is not taking about it, receipt of application and documents were not being done. And then what the number of frauds took place, more frauds took place. As for that, the government is concerned, in fact, Dharani, the persons who death basis there, no succession, that fellow straight away goes, somebody saying that I am successor and files a Dharani application, he gets incorporated all the lands. And without reference to, suppose some gut number, some 200 acres of number is there, some succession took place of 10-20 acres, that number is taken, and another subdivided number, that number, quoting that number, he files an application in Dharani, and he makes an application, this subdivided number, his name is incorporated. That's how, without any adjudication, without any mechanism of inquiry, abusing the provisions, certain digital transaction Dharani portals have been made. It's a controversial issue now that has been deleted. Now I need not go into that since deleted. That act total abolition, that as I said, section 5.3 mechanism with regard to incorporation, adjudication. It only provided that the section 5, suppose you want to sell it, one important feature was that not only Dharani portal is an issue, that's a different issue. Second is that the moment you want a transfer, you go to the agricultural land, Tahsildars have been made as a registrar, and that registrar will not only register it in respect to agriculture, he will also issue it in Patadar Pass. So that again, after incorporation, getting in Patadar Pass, all these inquiries have been given away. At one stroke, you are entitled for registration of agricultural land and also getting Patadar Pass. That's one facility, one of the good facility for the transaction which took subsequent to the Act 9 of 2020 is concerned. 6-7 of the said Act provides with regard to succession and will, etc. Will also first time has been provided the acceptance under the ROR Act, under that Act, 2020 Act. 6-7 also 7 is concerned. Decrees, etc. incorporated. Prior to that, Section 4 provides for it. but the specific recognition given under section 7 of the Act 9 of 20 for the degree section. That's automatic incorporation of the records and automatic getting, you are getting part of the passbooks and learning portal they call it. Learning portal incorporation. And only small window was provided in the section 10 of this Act. With regard to the only in respect of the already recorded name, suppose if the learning portal it has not been recorded or updated, that can be corrected. But that has also been a provision without reference, that provision has been misused. And now ultimately that has been repealed under Act 1 of 2025. Now as I see, as for the new Act is concerned, basic parameters appears to be Act 1 of 2025, latest Act is concerned, or same. They again brought back the adjudication mechanism which is provided in the old Act section 5 is concerned. They have again brought in that. Now Tehsildar has been provided. The Act 9 of section 5 has been rechanged in total. As for the agricultural land is concerned, this registrar will continue to be registrar, and registration and Patadar passbooks, that section 5, 6, 7 have been retained. Practically those provisions have been retained of the Act 9 of 2020. Guarantee concerned, they modified and said definitions. Definitions have been given saying that ROR portal. They said, instead of guarantee, they said ROR portal. This Act, apart from this, continuing that section 5, 6 provisions about it, the inquiry also has been provided, and also again brings the regulation of another this unregistered sale deeds under the Act, and also the provision with regard to the revision is concerned, commission in respect of the lands, inams, etc., or whatever the grants, etc., on the lands, revision is also provided. The earlier Act 1917 Act used to be, Tehsildar was the regularizing unregistered documents. Now this Act provides RDO has to do them, and little mechanism of inquiry, etc. Time period is limited under this Act. The basic differences appears to be for me is concerned section 4 of the Act and the definition. The first time the definition, mutation is concerned, in fact, lot of complaints used to be some judges used to complain, why you are using a mutation word, why you are using incorporation, why you are using, these are all kinds of this program. We used to get it out. Now the word mutation has been defined. And what are the lands to be mutation has been defined under the Act. Section 212 of the Bhuvarat Act. English version. This is one of the provision which really brings little clarity. For example, 212. Mutation means alteration in entries, record rights, account of the transfer rights, person holding part of thereof. The instruments are given, clarity, sale, gift, mortgage, exchange, partition, holding, will, inheritance, order, decree, award of local adalat, order of the revenue court, assignment, government policy, sealing, pattern, number of up to, lot of variety. All this can be brought for the mutation. With the clarity it has been given. Unlike old Act or this thing, section 5 of the Act 9 of 20 also. Another important is I see concern is concerned. Section 4.2 is one of the important provisions in incorporated in this domain. I do not know whether how they implement it. That's a different. We have all good enactments, but all the problems will be implementation problems. A separate record shall be maintained, prepared, updated, maintained, Abadi. And the Gramakattam Abadi also defined. What is the Gramakattam also defined? Which was a lot of problems used to be there with regard to that is also defined. Section 4.2 contemplates separate record rights shall be prepared, updated, and maintained for Abadi and non-agricultural lands. If they do correctly, suppose this record is prepared, it's a wonderful because online record is appears to be now a portal. You will definitely know what is the agricultural land, what are the rights are concerned about it, what is the non-agricultural land. I don't know how they prepare it. Section 4.1 contemplates preparation of the updating of the record. Section 4.2 contemplates it. And also in fact this also says survey part of it also section 13 is concerned, Section 13, also one of the good provision, they prepared under Section 4, updated under Section 567, be incorporated electronically in the village account, revenue, subject accounts may be necessary. This updating also record village account survey records is also one of the important provisions if they make it. Similar provisions of the Section 11 etc. also have been incorporated. One more is that instead of after the revenue, I don't know, so many appeals have been provided. It could have been one RDO and thereafter could have been land reform tribunal, but the Section 15 and 16 also provides by the collector also against the RDO's order and etc. multiplying unnecessary another remedies. But Section criminal land reforms will be also contemplated. If that is consisting of a judicial or a statutory flavor, it will be good. Good thing about it. One of the more important another provision I see, if you compare what is the changes that have been made which have a good this thing is concerned. Section 9. The Buddha card, they are going to issue Buddha number is going to be issued. This it appears rules have been framed in the month of June 2025 is will come into force. Section 9 is that which contemplates the Buddha parcel card to which Appellate Act applies to be assigned automatically in such a manner. Provided that the assignment of the permanent Buddhas shall take into consideration geographical period, land shape, and determine coordinates, so and so ownership as per the records of rights. Provided further that Buddha numbers will be both temporary, permanent, specially reserved for the series be assigned to the parcel of lands, to the land, government, etc., endowment, etc. And private persons also too contemplates Buddha cards for both temporary, permanent shall be generated all parcel of the land. We will have a land, like a credit card, we will have a land in respect of these numbers. There is also supposed to be done. I think this will have, because this act will be comparing with 1971 Act, Act 9 of 26 of 71, and comparing with the 9 of 2020, this appears to be very broadly covers, provided those survey incorporations, those incorporations, Buddha card are issued, and update, the important is that update. In fact, actually, I don't know why they have not incorporated initially all two was that first you undertake survey, digitalization of the survey, and thereafter updating it by the government, then all these inquiries should be third step. So that step is not contemplated, whatever the reasons about it. But anyhow, this act little more wider, little more about it. Let us hope that in working out certainly such an amendment may come. This act will covers as per the records of rights. That may not decide either, but prior facing either, which we can rely before the various authorities, including the courts. So basically this, and another area where is concerned is Inam is concerned, that area is a full. There also, whether recent judgment is concerned, Section 38 prevails, or in Abolition Act, protected tenant getting a certificate. There's another controversy area which was there. And recently Supreme Court has decided, Court of Caesar in this case. 38E certificate as the primary listing document, not the 38E tenant. 38E tenancy is the primary document. In Abolition Act has to be it. There's another area, judgment is certain. There's a bar, we are legally concerned about it. So transfer of property, you all know that how 54 section transfer of property applies, what is the effect of registration on this 17 model registration act, registration has to be done, the effect under section 3 act registration, all we know. I think this is some and substance, any other questions in the required, I'll give it otherwise. This is broadly, I think, I covered subjects which may regularly recur the problems. Thank you. Thank you. I am not expert in the field. To the extent of my ability, I explain to you.
Thank you for your presence service, and also thank you to the senior VP who accepted our request on behalf of the association and giving a valuable on the revenue law. Now I request by Secretary to
before the deadline, I think our Honorable President of our Association to honor the senior conference vocation.
Good evening, sir. Senior officer, good evening. And my dear brother and sister delegates, good evening to all of you. Today, revenue laws. Today we have arranged a first program as revenue laws as practiced in our elections. We will conduct series of lectures with designated senior counsels if possible. We will use all our last experience of our senior counsels. We will continue the same. Please avail. I request all the advocates to avail the same. Sir, today we have listened wonderful lecture on revenue laws. How the revenue laws incorporated in our Telangana state from the abolition of Jagis to till incorporation of Dubarfi Act. All the acts were covered. Tenancy laws, Inam Abolition Act, as well as the doubt expressed by one of the senior counsel with regard to section 40. Sir covered the judgment of the Honorable V.S. Rao Garu and LNRJ, who are discussed. That after discussion, when there is dispute, if the dispute is not there, the authority is correct. If the dispute is there, the disputed person who raised dispute, they have to approach civil court. Sir, most probably all the doubts are covered in your lecture. Sir, we are very grateful to you for coming and giving this lecture. One small announcement, please all the advocates, brothers and sisters, join for snacks and hide, please.
Nitin Babu.